Do you know a consumer can be punished for up to 7 years under Consumer Protection Act? I'm not talking of companies, no. I'm talking of consumers. And we associate the Consumer Protection Act for the protection of consumers against the companies in case of any defect in goods or deficiency in services. So it is very critically important to know and to understand the other side of the law as well for the companies and for the service providers, and also for the consumers, that what not to do in the consumer courts. So how a consumer can be punished? So the relevant provision of law which we are talking about today is section 38 subsection 10 of Consumer Protection Act. You may note it down. You may note it down because it's a very unexplored provision. There are very less miscellaneous applications filed on 3810 of CPA 2019. The reason being it's a very new provision, just 4-year-old. So there is a lot to explore in this provision. If we read it, 3810 of Consumer Protection Act 2019, so we have to read other law also to derive the meaning. This law states, 3810 states that for the purpose of 193 of Indian Penal Code, the consumer court is a criminal court. This distinction is very important because criminal court can punish. Consumer court is a deemed civil court. So now 3810 says for the purpose of 193 IPC, consumer court is a criminal court. So it can exercise the power of the magistrate, the presiding judge, presiding member of consumer courts will exercise the power of a magistrate to punish the litigant. Now punish for what? Let us read section 193. Section 193 is equivalent to the section 229 of the new law Bharatiya Nyaya Sanhita 2023. So it states that if any party, including the consumer, files any false or frivolous evidence before the court, in that case he will be punished for up to 7 years and also be liable to fine. And right now, I want to highlight that this provision, this language was not present in the old Consumer Protection Act of 1986, the original Consumer Protection Act. It got repealed after the adoption of the new CPA 2019, and CPA 2019 was enforced the very next year, 2020. The old law states that the consumer court is a civil court, so it will note down the complaint and will transfer to the magistrate, and magistrate will decide and accordingly punish the litigant. But now there is no need to transfer because consumer court is a criminal court. Consumer court, the presiding judge is a magistrate, so it can decide and punish the frivolous litigant. So this change is a very big change, and it shows a very strong legislative intent in the favor of the new Consumer Protection Act, this section 3810, to throw out the frivolous litigants out of the court, to save the pure stream of justice, and to show that there is zero tolerance policy for fraud in court. So in the end, I would like to ask you one question, that do you support this new law of punishing the consumers under Consumer Protection Act 2019 to maintain the credibility of the consumer courts and to throw out the undeserving litigants? Or are you of the opinion that only the companies must be penalized under CPA and consumers must not be burdened? What is your opinion? I shall wait for it in the comment section.